I practice in Toronto with the law firm of Greenspan, Humphrey Levine. I am in my 6th year of practice and I am a Windsor grad, class of 2003. Well, I'll start with one of the major concerns, I think, from the defense bar. And a lot of the recent dialogue has been surrounding the mandatory minimums, the increased reliance by Parliament on mandatory minimum sentences. And I expect that there will be charter challenges to some of those offenses. We have mandatory minimums now. They have been challenged in the past and have been upheld. How successful that's going to be, I don't know, but I think that the concern is with the offenses that have been captured that fall at the lower end in terms of gravity. So lower end drug offenses that are now going to be subject to mandatory minimum sentences of imprisonment. I think those kinds of cases will see the charter used to try to say that it's unconstitutional, that somebody who has committed a low-end offense should get a mandatory jail sentence, when, you know, for the last number of years that very same crime would attract a non-custodial sentence. Turning to Section 11B, when you look at still the leading cases on Section 11B, which deals with an accused right to be tried within a reasonable time, we're talking about cases like Askoff from 1990, the case of Moran from 1992. These cases are now more than 20 years old. And we're still seeing the same trends in our courts. I can tell you in downtown Toronto, it's not unusual to have to wait 10 months for an accused to get a trial date. I know some of the smaller jurisdictions, it's not quite so long, but over the past 20 years, the resources have not been allocated to our trial courts to get people an opportunity to have trials in a much speedier fashion. So I think when along comes Bill C-10 and we have a lot stiffer penalties on the table, people will be setting more trials. There will be less of an inclination and incentive, frankly, for people to resolve their cases by way of guilty pleas. So when we add that volume on top of what we already have, I think the only reasonable result is going to be to create more delay in the system. I should say in Ontario that there's been some recent cases that are suggesting that our courts may be more tolerant of institutional delay. A case called Tran from the Ontario Court of Appeal that says from the time that an accused person sets their trial date to the time that their trial starts, that period that has always been treated as straight institutional delay, there's now a chunk of that time that gets attributed to defense counsel, and defense counsel needing to clear their calendar and to prepare for trial. So when I say it's defense counsel, it's just deemed as a period of time that's necessary to prepare the case, and it fits in with a category that's called the inherent time requirements of the case. So what that does is that just carves out a period of time that I think our courts are going to be much more tolerant of at the end of the day. So we'll have to see what happens.